Okay, we're a little after 6:30, and that's really loud, sorry. Thank you for the visual reaction, though, because that... Is that better? Hello, hello, hello. Thank you, everyone, for being... Oh, so still too loud, Chris. Okay, how about now? Still too much? This is okay? I can also talk softer. Thank you, everyone, for being here for Moot Court 2025. This is the second year we've done this. I'm Professor Chick. For those that don't know me, this event is kind of brought together by a couple of organizations on campus. I'm the director of the pre-law program. That's one of the organizations. The others, I'm one of the co-directors of the Institute of Public Service with my wonderful two co-directors in the back, Professor Elder and Professor McKinney. So kind of a joint effort there on campus. And then I'm going to turn it over in just a second to our wonderful alumni here, but specifically Tom in the middle. Many of you have met him. This was his idea. He came to a Professor Elder's careers in political science class and said, I have run these moot court competitions before. I'd love to do it here at Hartwick. So this is his problem that he came up with. This is his time. These are his resources. It's a tremendous lift for him. And Tom, you know, and all the alums that are here tonight, we're extremely grateful. I just want to say thank you again, and maybe we can give Tom a buzz. Thank you very much. And so with that, I'm going to turn it over to Tom, who will both introduce himself a little further and then maybe just explain the actual rules of the competition before we get going. The only other small announcement, there is still a lot of food out in the back. So you should feel free, if you want to get up really quickly during a thing, we're leaving that door open on purpose because we don't want to throw any food out. Okay, so yeah, that's all I have to say. Thanks a lot.
Good evening, everybody. Thank you for being here. So before we get started, quickly, what you'll end up seeing, this is appellate advocacy. The students in front of you will act as though they're in front of the Supreme Court. This issue deals with the Fourth Amendment. Essentially, in the O'Yarn School District, they thought that they had a drug problem from various reasons. The dialect that the students used in discussion, finding marijuana at different points, etc. Some other drugs you'll hear. They worked with the local sheriff's office to do drug sniffs, not of the students' persons, but of their belongings. It was uncovered that there was a loophole, and the search started to expand. They started to use a 45-pound German Shorthand pointer named Stella. Happens to be my mom's dog, and my mom is also Star, the handler in this problem. And they started to do sniffs in classrooms with the students present. So the way it works is you'll hear from the petitioners. Those people lost last court. That's why they're petitioning to the Supreme Court. They're saying we think that the court messed up for this particular reason. And the school is the respondent. So they won, and they want the lower court's decision affirmed. So just like a real court, we have a bailiff. He's armed over there. So we can't make any noise. Otherwise, you'll be court-martialed, and he's a quick trigger, so just watch out. He's much more dangerous than Stella. Outside of that, I'm Tom Holmgren. I graduated in the class of 2013 here, and went on to UConn Law School. I presently work in New York City. I'm also barred in California, New Jersey, Massachusetts. I do environmental stuff, construction stuff, commercial stuff, some other boring stuff. But without further ado, I'll just we'll have the judges introduce themselves real fast, and I'll call the case, and we'll get this thing going.
Good evening, everybody. It's a pleasure to be here again. Thank you, Tom, Professor Chick, Professor McKinney, and Professor Elder for inviting me back. I'm a 2002 alum. I'm also an attorney. I practice in Albany. I'm a civil rights attorney, so I do some of the cases that you guys are going to be presenting to us, some First Amendment cases, 14th Amendment cases, discrimination cases, and I have had the pleasure of arguing before numerous different courts and I know how nerve-wracking it is. And if you're not feeling nervous, you're not human. Okay? So being nervous is okay. I know you're over-prepared for this, and you guys are going to do great. And the experience that Hartwick is providing you of having the opportunity to present arguments before a panel of judges is immeasurable. So take advantage of it, enjoy, have fun, and I'm looking forward to hearing your arguments.
Good evening, everybody. My name is Aaron Carbone. I'm a 2003 alum. Also practice in Albany. I have a small boutique firm up in that area and litigate myself primarily in the areas of health law and estate law and for the appellate division at the state level, not the federal level, quite a bit. But I can say, like Carlo and Tom, I've been through this. We've all done moot court in our law school career, and it is a wonderful opportunity and take advantage of it now. And really happy to see you guys. Congratulations for making this far. It's not a small feat, and really looking forward to hearing your guys' arguments. So good luck.
And the last bit of context I should give is, if anyone didn't do it, is you'll hear about two issues tonight. The first issue is whether or not the dog sniffs constituted a search for Fourth Amendment purposes. And then if the court was to find that there was a search, the argument will be whether it was a reasonable search or reasonable or not, the inference on the privacy. So with that, for the remainder of the next hour, we're in the United States Supreme Court. With that, the Supreme Court of the United States calls the case Walter Matthews versus O'Yarn Hills School District. Petitioner, you may proceed when ready.
Thank you, Your Honors, and may it please the Court. My name is John Reichel, and I and my co-counselor Cooper Cohen represent the petitioners, Walter Matthews, Hillary Duff, and Jeff Teague. Issue 1 asks whether or not police-directed sniffs of students' bodies in their classrooms by drug-detecting dogs constitute searches under the Fourth Amendment. We submit that they do. The Fourth Amendment begins with the right to be secure, the right of the people to be secure in their persons. The framers feared nothing more than government agents intruding upon the body without cause. Now imagine telling James Madison that officers would march trained drug-detecting dogs in the classrooms and search students' groins and midsections. Madison would not ask whether or not that constitutes a search. He would ask whether or not we had lost our minds. Our argument proceeds in 4 parts. 1, the Fourth Amendment protects people, not places. 2, the sniff of a human body intrudes on personal privacy and dignity in a way that sniffs on property do not. 3, precedent from Katz to Jardines compels treating this conduct as a search. And 4, the human dignity interest makes this intrusion a search. The Fourth Amendment protects people, not places. The text of the amendment begins with the right of the people to be secure in their persons.
Counsel, is consent a legal exception?
Yes.
Let me speak to the microphone. Is consent a legal exception to the Fourth Amendment?
If you consent to be searched, yes.
Okay. How does the fact that the parents of the students involved consented to the policy of the school district, how should that affect our analysis of this case?
Well, our analysis of this case should consider one fact, that these students are here under compulsory education, and that the school policy subjects them to these searches, and they do not really have the option to opt out. Granted, nowhere in the case did the parents or students complain, but prior to experiencing these searches, there was not really much of a firsthand experience to complain off of. So the amendment begins with the right of the people to be secure in their persons. As Katz v. the United States teaches, the Fourth Amendment governs the privacy upon which one justifiably relies. Further, Mr. Justice Stewart and Katz states,
Has any court found that there's an expectation, not of the body, but of things outside the body, i.e. the air outside the body this dog is sniffing?
Yes. The New York State Court of Appeals in the People v. Butler in 2023 ruled that searches of the person, even the surrounding atmosphere of the person, do constitute searches under the Fourth Amendment. So Mr. Justice Stewart's and Katz, yes.
Doesn't Katz talk about the actual subjective expectation of privacy?
Yeah, that's correct.
Okay, and that expectation has to be reasonable, correct?
Yes.
And what expectation of privacy do students have on odors emanating from their body?
So there's a few different ways to approach that question. One, if we consider the case of Florida v. Jardines, and secondly, which that is going to bring in this concept of an implied social license, that you as an individual expect some type of privacy. I may ask you, Your Honor, would you be comfortable if I were to conduct a search on you 6 to 7 inches from your groin or midsection that is just outside of the implied social constructs of society and is what the court should consider when ruling on this case if we want to establish a lower privacy precedent?
You talk about search, but my understanding here is that there was no physical touching
Yes.
of these students, correct?
And I will concede that there was no touching by the canine unit in this case. And under Terry v. Ohio, it was ruled that even the least touching of the individual constitutes a search. And in this case, there was no touching. But if we stand in violation of that social construct, as discussed in New York v. Butler, we stand to implicate this as a search.
Would I be violating your Fourth Amendment right if I complimented you on your cologne?
No,
Why
you would
not?
not be. Well, because you are not entering my space for the purpose of gathering investigative material. For example, the court stated it is not part of ordinary social customs for another person to enter the space directly surrounding someone's body for the purpose of obtaining information. Now, for that example I provided before, if I were to approach you and sniff you from 6 to 7 inches away purely for the purpose of whether or not you had contraband on you, that would be outside of typical social connotations and expectations.
The distinction has to do with the law enforcement purpose of the conduct. So, in other words, aren't police officers allowed to, when stopping a vehicle, to smell to see if the driver has any odor of alcohol, and isn't it true that those are constitutionally approved conduct by a law enforcement officer?
Yes, I think an important distinction there, though, is that those typically occur during routine traffic stops. There's some other probable cause associated with that. So say you are swerving on the road and the window opens of your car and you smell alcohol. That is a reasonable suspicion to further investigate that situation. And also in Place v. Caballes, Place and the Caballes cases, we established that it's okay for law enforcement to search luggage or car exteriors or interiors with scent detection canines. But in this case, this extends to the person and violates that critical social construct.
But doesn't the school have an interest in protecting its students?
Yes.
Making this an exception?
Yes, the school obviously has an interest in protecting its students. I don't think anybody's going to agree that drug use is good in any circumstance. But also, in Caballes, it was determined that the canine sniffs can only reveal the presence or absence of contraband. In this case, it's not true. Say one of these students had a parent that was riddled with pain from chemotherapy treatment, that was using legal medical marijuana in the state. Now, that student has to experience a false positive because there could be a trace of marijuana from their parents on their body and deal with the social connotation of now having a dog alert to you that you have drugs on your body. The school's policy prior to this was more...
So are you arguing that the individual's interest outweighs the school's interest in this instance?
And this is teetering into my co-counsel's argument of reasonableness. However, the school does have an interest in maintaining security and curtailing drug use, and the previous policy was effective in doing that, and which my co-counsel will cover.
Was the prior policy a search?
The prior policy was not a search under Place in Caballes because it was only focused on searching lockers in the hallways and luggage, so stuffs. Our individuals are not objects, right? So in the detection of sniffing stuffs or objects, it only reveals the presence or absence of contraband. Now, one thing that's really important to consider here is that the human dignity interest here makes this intrusion a search. even minimal invasions of the body count. In Terry v. Ohio, it was recognized that this principle of least touching by government agents for investigative purpose implicates the Fourth Amendment. While Stella did not make full contact, and that differs from the case of Horton v. Goose Creek, the deliberate placement of a trained police dog is functionally equivalent to a tactile inspection. It is an investigative technique that is aimed directly at the person. In the court in Skinner v. the Railway Labor Executives, they called this the most personal and deep-rooted expectation of privacy.
What should we take out of the fact that no students were ever prosecuted for finding drugs on their person? So that starts to make me doubt whether this is really, police activity.
Yes, and that's an interesting point to bring up. But interestingly, when these searches are conducted, the school officials are effectively deputized by the police department. They go classroom to classroom with the police officers proceeding through these sniffs. And then after there's a detection and say contraband is found as a result of one of these sniffs, they then turn that evidence over to the police. And I will concede there has been no follow-up investigations or consequences associated with that, but that opens up a whole can of worms of privacy issues. Now, Jones and Jardines confirmed that physical intrusions on protected areas are searches. In the United States v. Jones, the court affirmed that the Fourth Amendment is triggered when the government obtains information by physically intruding on persons, houses, papers, or effects. And in Florida v. Jardines, the court held that bringing a dog onto the curtilage of a home was a search because it exceeded the implied social license I was mentioning before. If leading a dog a few feet onto a porch to smell a door violates the amendment, surely leading a dog a few inches from a children's groin would do the same.
Wasn't the interest in Jardine actually in property interest and the officers? And the question was whether officers had trespassed onto the property before conducting their search. Wasn't the issue a little different than what we're facing here?
That's correct, but Jardine still does raise the question of expected privacy and those social licenses, right? So you do not expect officers to arrive on your property and sniff it and see if there is contraband on your property. That is not a social connotation, and a ruling in favor of the district essentially establishes that the acceptable social license in this situation is allowing dogs to come in and detect your bodily emanations. And if we are looking into the physical aspect of this, the actual act of smelling requires you to pick up particles that are emitted off these people. So in that case, it is functionally a tactile inspection. This case is not about property trespass, as you mentioned, but about bodily, yes.
How do you reconcile Renfro?
Renfro? I apologize, Your Honor, I'm not prepared to answer at this moment. I'll submit it in a supplementary brief.
Fair.
So, with that said, the case is not about property trespass, as you mentioned, but is about bodily intrusion. The personal space or curtilage around one's body is especially that of a teenager, is every bit as constitutionally protected as the front doorstep of your home. Your Honors, the court does not write on a blank slate. State Supreme Courts have already confronted this question. As I mentioned before, in People v. Butler in 2023, the New York State Court of Appeals held that a police-directed dog sniff that invades the personal space immediately around the body is a search.
This seems like Kylo to me with essentially enhanced technology, the ability for the dog to sniff. And isn't this one that society will recognize as being comfortable with or reasonable? Because dogs are everywhere. And also, drug sniffing dogs are also everywhere. They're at train stations, they're at airports. So why is this not just an amplified technology that society's fine with?
I really do believe that question goes back to the social licensing. If it is considered rude to allow pets to sniff others, introducing a trained drug detecting dog to sniff your groin and midsection certainly is intrusive and unacceptable under any pre-established social expectations. The case here, Your Honor, effectively allows the school to conduct searches without individualized suspicion. Interestingly, Butler is not establishing this broad policy statement. It is a point-blank legal recognition that the personal space around the human body is a protected area, and that using a dog to breach it constitutes a search. It is against those social expectations.
Did Butler address how close the dog would have to be for it to constitute a search?
To my knowledge, the Butler did not explicitly say the distance, but the police officers in that case pulled over a man who claimed to be having $1,000 of cash in his pocket, and then they conducted a sniff search and discovered that he was carrying like 40 to 50 vials of heroin on him. So with that, they were close enough to be able to see him and bring the dog into his bodily presence. Your Honors, calling this a search does not expand the Fourth Amendment. It simply applies the precedent you already have. Katz protects people, not places. Terry teaches that even minimal intrusions directed at the body trigger constitutional scrutiny. Jones confirms that even while the government physically intrudes to obtain information, a search has happened. And Jardines makes clear that deploying a drug dog into a constitutionally protected space exceeds that social license. If sniffing at the edge of a porch is a search, then a dog sniff inches from a student's body certainly is. To hold otherwise would create a new suspicionless exception, allowing law enforcement to conduct bodily investigations of entire classrooms without cause. We're not asking the court to expand rights, we're asking it to preserve them. Thank you, Your Honors.
You may proceed when ready, counsel.
Thank you, Your Honor. First and foremost, I would like to reserve 3 of my 15 minutes for rebuttal.
Granted.
Thank you. Your Honor, and may it please the court, I am here to discuss the issue of whether or not the Yarn Hill School District's expanded drug sniffing policy was reasonable. And I submit that it simply isn't, Your Honor, and for a few different reasons. First and foremost, the school district's original policy was working as intended, and their grounds for expansion are shaky at best. Second, this new policy raises a few interesting concerns. And third, precedent simply does not back up the grounds for this new expanded policy. Now, first and foremost, it is, I'm willing to admit that the school district had a drug problem and they sought out to meet it. In the 2019 to 2020 academic year, there was a notable uptick in drug-related incidents at the Yarn Hill School District compared to years prior. In one incident alone, they caught a drug smuggling ring consisting of 6 to 7 students, whereas in prior years they would only ever encounter maybe 3 to 8 incidents. Your Honor, in response to this uptick, the school implemented a policy of sniffing unattended bags, lockers, and students' cars. Now, this policy was working because in the 2020 to 2021 academic year, there was a decrease from the previous academic year of incidents of drug incidents in the school district. The only reason that the school decided to expand to the new policy was because of the existence of a so-called loophole in the original one, which one student alerted school officials to. I submit that this loophole, which is instead of leaving your drugs in your locker, in your bag, or in your car, you just keep it on your person. It gets around the original sniffs. Well, the school district saw that and thought it reasonable to go to this new policy. But I argue that it simply is not. First and foremost, I don't see how effective of a loophole this is, seeing as the student in question was caught by school officials. Secondly, there's only one documented instance of a student claiming to utilize this loophole.
Counsel, but the fact that this particular student was caught, does that make it less reasonable for a school district to have a legitimate concern about a potential loophole in their policy?
Well, I think you raise a good point, Your Honor. It is reasonable for the school district to have concerns about this loophole, but I still submit that I don't see how it is a very effective loophole, seeing as the student in question was caught. But the school could have taken other measures to counteract it, rather than the drastic expansion that they did take.
So let me give you another hypothetical. There's a small town with a string of bars on Main Street, and their police conduct DWI stops on Main Street. they happen to catch an individual at a local gas station that doesn't exist on Main Street for driving under the influence. While during the arrest, the person being arrested says, "No one drives on Main Street. We drive on River Street from the bars." Doesn't that alert the police to a large loophole in their policy, similar to the one that the school was trying to correct here?
You know, Your Honor, I think that's a very good hypothetical, but I would offer this, it's one thing for a student, or in your hypothetical, an individual caught in this scenario, to say that other people are utilizing it to evade, detection. But it's another thing for the school district, or in your hypothetical, law enforcement, to actually discover more people circumnavigating the original policy. We cannot simply we cannot let the school district base its expansion on the possibility that people could be doing wrong.
Counselor, wasn't a student that had his backpack and personal effects sniffed found to have drugs on his person the same day or later in that day? Prior to the change in the expansion of sniffs to persons?
I'm unfamiliar with the incident that you were regarding, Your Honor.
Yes. Okay.
But even if an individual was found with drugs on their person prior to the expansion of the drug sniffing policy, I would still submit, Your Honor, that the student in question was found. Your Honor.
Yeah, and Counsel, you're familiar with the special needs doctrine, correct?
Yes, Your Honor, I am familiar.
Do you agree that school districts have a legitimate interest in keeping their student body safe from drugs in this case? Would you agree with that?
I would agree, Your Honor.
And so your position is that the policy at issue here is should not be permitted. It's unconstitutional because it's unreasonable.
Yes.
And you agree with me that under the special needs doctrine, that this is a less exacting, it's a more laid back standard than what we would expect of law enforcement.
Yes, Your Honor. So
So how would you distinguish this policy of having dogs sniffing around students without touching them from the constitutionality of sniffing dogs operating in airports, for instance? What is the distinction? Why is one reasonable and this one is unreasonable?
well, to the special needs context, Your Honor, first and foremost, special needs scenarios were established by the court in the case of Griffin v. Wisconsin. But if that were the only scenario, I would say that it's not applicable here because in Griffin v. Wisconsin, it was regarding the searching of a drug probationer's house. But the court has extended special needs to school settings in the case of Veronia v. Acton and Board of Education v. Earls. But I would argue that this case differs fundamentally from that of Veronia and Earls, because in Veronia and Earls, it dealt with students participating in sports in Veronia and students participating in non-sports extracurriculars in Earls. And I would argue that in those scenarios, the school does have a special needs context because these students are offering them, they are accepting that by choosing to do these extracurriculars, they are accepting that there is a lessened standard of privacy. Whereas in this case, all of the students are forced to go to class. We have compulsory education in this country.
But in Veronia and Earls, it dealt with urinalysis, correct?
Yes, Your Honor.
And you would agree that the process of them delivering urine to be tested is far more intimate than a dog walking past students?
I would actually argue the opposite, Your Honor. In the case of Veronia and Earls with the urinalysis testing, that is taking place in a secure room. It is just you in that room. You urinate into the cup and you provide it for testing purposes. But
don't you do that under watchful eyes? In this case, the dog is walking past people. In that case, there's someone monitoring to make sure that it's your genitalia placing urine into a dispensable cup.
Well, you are correct, Your Honor. While there may be that person watching, it differs from the drug sniffs in this expanded policy in that the drug sniffings near the students' bodies are taking place in classrooms where students are sitting next to their peers. And as we have seen in the case of Ms. Hillary Duff, false positives can occur. And if a false positive occurs in this case, the students' peers are under the impression that, this dog is trained to sniff for drugs and will alert for drugs or traces of drugs. And so when they see an alert happen, real or not, they are instantly going to jump to, oh my God, that student is associated with drugs in some way. And so that the student in question that had the false or real, hit by the dog, has to go the rest of their school careers potentially being ridiculed by their peers for this, because of this new policy.
You're talking about the false positive, but what about the misses? So what about, was Stella able to detect fentanyl?
The dog has not been trained to detect fentanyl, as per the Yarn Hill Sheriff's Department.
Well, let's say if she was able to detect fentanyl, if they had an instance of finding fentanyl on campus on multiple occasions, would that change your analysis? And then, because of the strength of the drug as opposed to marijuana, et cetera. And then doesn't the school have to really worry about the chance that someone could actually die from consuming it? Shouldn't that, weigh very heavily on the scale of reasonableness here?
I would not argue that the school has an interest in protecting the health and safety of their students, especially in this hypothetical where fentanyl is present on campus. But I would also submit that there has been an incident of a student caught smoking methamphetamine in the bathroom on campus, and the school acted in the same accordance as with this policy. And I would still submit that this expanded policy is unreasonable, even in your hypothetical where there is incidents of fentanyl on campus, you know what I mean? Even though the school has a legitimate interest in protecting the health and safety of the students, it does not outweigh the students' privacy concerns, and it does not add more credibility to this extended policy. We also can't the school district can't be allowed to base this expanded policy on the possibility that students could have harm done to them. As Justice Holmgren notes in his dissent with the appellate court, we can all agree that child pornography is bad, but the possibility that a student has child pornography on their phones does not give district officials the right to go through and start searching through phones just in case somebody may or may not possess that. And I would say the same still applies here.
But isn't there a distinction here in that there is, in fact, drugs that have been found at the school and the school is trying to protect its students?
Well, you're right. There is that distinction, Your Honor. But as I noted earlier, the original policy was working. Drug incidents in the district from the 2019-2020 academic year dropped when we consider the 2020 to 2021 academic year. Ultimately, Your Honor, I would offer that the school did not have to jump straight from sniffing of bags, unattended bags, lockers, and cars, right up to this extreme policy of sniffing in the air surrounding other students. They could have taken other measures if they were so worried about the original loophole to the policy.
But what other measures could they take? Because the drug sniffing dog seems like the perfect test. The dog is intended to alert only in the presence of contraband. So what other steps would there be to closing that loophole than this drug sniffing dog?
Right, that's a good question, Your Honor. And I submit that the original policy was working in finding contraband in lockers and other areas that the students are not. And if they're worried about students potentially circumnavigating it, the school could have offered up other alternatives, such as maybe potentially a tip reward system, encouraging students to alert school authorities if they have any knowledge of other students that are attempting to circumnavigate the original policy. Ultimately, Your Honor, as the old saying goes, the road to hell is paved with good intentions. Nobody is going to stand here and argue that the school does not have a legitimate interest in protecting the health and safety of its students. But in order to achieve this goal, they cannot do so by walking upon the Fourth Amendment rights of said students. Thank you, Your Honor.
Thank you, counsel. We'll hear from you on rebuttal. Respondent, you may proceed when ready.
I'm ready. Okay. May it please the court, my name is Sam Tambura, and my co-counsel Adelia Iniova and I are here to represent Yarn Hill School Corporation against Walter Matthews, Hillary Duff, and Jeff Teague. I am here to prove that the police directed sniffing of students in public schools classrooms by a drug detecting dog are not searches that implicate the Fourth Amendment. The Fourth Amendment protects the right of a person to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures, and in this case, it does not need to be implicated. Here, the defendant, Yarn Hills Corporation, did not violate the plaintiff's Fourth Amendment rights by having a dog named Scylla sniff the air around students' persons. According to United States v. Jacobson 466, government action is a search when it infringes upon an expectation of privacy that is prepared to be considered. Nowhere in this case did Stella infringe upon that expectation of privacy. Here, Stella and Yarn Hills School Corporation did not infringe on an expectation of privacy. The plaintiff might bring up 3 cases where students felt as if that they were searched or had the right of privacy infringed upon, but I'm here to bring to light that these cases are not true, and I'm here to prove beyond a reasonable doubt that the school did not infringe upon anyone's privacy or violate anyone's Fourth Amendment rights. First, in the case of Walter Matthews. Walter Matthews did not get searched. Stella walked up to him and simply smelled the air around him. Nowhere did Stella touch Mr. Matthews in this case, and all she did was just smell the air around him.
Counsel, I'm going to ask you the same question I asked your colleague. What difference does it make to your argument that there was no objections to the policy by any of the parents of these students when the policy was initiated?
Well, there was no objections, and not only that, the school communicated to the students and parents about this policy. And in the document, it did say that if anyone had a problem with this policy, the school was more than welcome and more than willing to adhere to those.
So how does that help your position here before us with respect to whether there was a search or not a search in this case?
I think it just wasn't a search. Like, by the parents and the families knowing about these, about Stella going into classrooms, they basically consented to it happening. So that makes it not a search.
So legal exception to the Fourth Amendment protections against unreasonable searches and seizures?
I'm sorry, can you rephrase
Is
the question?
consent a legal exception to the Fourth Amendment protections against unreasonable searches and seizures?
Not in this case, but we also have to remember that Stella sniffing the air around the student's persons is not considered a search. The next case is going to be Jeff Teague.
What if a local, so there's, let's say it's a locality, some local Florida, Tampa, Florida, has a big issue with drugs. And the police force there says, we want to deal with this issue, so if you leave your car in, a parking lot, whatever, we're going to search it for drugs. And no one says anything. No, they just put it on a big billboard, and no one says anything. Does everyone consented to the search?
No, but like I'm saying here, Stella sniffing the air around the student's persons is not considered a search. In that case, people are just leaving their cars, and then the police is announcing that they're going to be searching their cars. But here, that is not what's happening.
How do you reconcile then, though, that it's illegal to sniff out the curtilage of a home, but your personal space is not subject to any Fourth Amendment protections?
It's because for it to be considered a search, there has to be a reasonable expectation of privacy. If I'm walking around and I sprayed perfume around myself and people smell this perfume, is that also considered a search because they can smell the air around me? The answer is simply no.
But are you always walking around drug-sniffing dogs?
No, but if a dog smelled me and they smelled the perfume on my person, that would also not be considered a search. Here we have to think about the expectation of privacy. If someone goes on and gives the public this information, it cannot be considered a search because this is information that they're declaring to the public. If you made it public, it cannot be considered a search.
So the searches that occurred in this case involving sniffing dogs, different from the searches involving the requirement that students provide urine samples and blood samples?
Yes. So
And how so?
Oh, I'm sorry. Oh, yes. In Veronica and Earls, it had their students and student athletes provide urine samples to look for if the students were doing drugs or not. Those are 2 very different cases. In those cases, student number 1 were infringing upon a greater risk of privacy. Firstly, they had to pee in front of somebody. That is already uncomfortable. It already infringes upon that privacy. Secondly, when the school corporations, they look through this urine, they're giving access to more information. Throughout a student's urine, not only can they tell if they're doing drugs or not, but they could also have access to their medical records. They can have access to if they're doing drugs outside of school or not. Well, in this case, we're just simply deterring students from doing drugs in school. If we, yes.
Counsel, my understanding is in Veronia, it was students involved in extracurricular sports, and then Earls, I believe, also dealt with non-sports and also in a military context. Those seem to be very different standards than compulsory education where the students must go. And also, the second part I'd like you to address, how that distinction shouldn't weigh on our minds, is the fact that were the students placed on lockdown and they weren't free to leave the classroom during this period where Stella would come into the room and sniff?
Yes, the students were placed on lockdown and they were not permitted to leave their classrooms. But like I said again, no one had really said anything that this was a problem of any sorts. And in some cases, of course, like when people go through like routine traffic stop, they're also placed on lockdown. Yet that also was not considered a search in.
Would it affect our analysis at all if one student's parent said something to the notice and said, I don't want my child to be a part of this? Would that fundamentally change our analysis whether or not this was a search?
It would fundamentally change a small piece of it. If a parent had stated that, oh, my students, I do not want them to be a part of the dogs, of Stella smelling them because of maybe allergies or religious reasons, then yes, we would consider that. But it would not change the fact that this is not considered a search, Your Honor. The next case is going to be Jeff Teague's case. Here, Jeff Teague felt as if his fundamental rights of privacy had been infringed upon. So what happened at school is Jeff was wearing a very oversized shirt and very short shorts, and he ended up lunging towards Stella, and after he lunged towards Stella, Stella jumped towards him, and then he ended up exposing his shorts to the public. Now, Mr. Jeff Teague is saying that this is a search because he felt as if his privacy was infringed upon, while in reality, he's the one who triggered Stella. He jumped toward her. Yes, Your Honor.
The opposing counsel relies on Butler.
Mm-hmm.
How is this distinguishable?
Sorry. Well, in Butler, it states that the most prevalent in 2022 New York Court of Appeals case ruled that a canine sniff of a person is a search under the Fourth Amendment requiring at least reasonable suspicion. I'm here saying that Stella is the reasonable suspicion. I'm not saying that the school itself doesn't necessarily search their students. We've seen this happen. Mrs. Duff was searched by the principal and the school administration, but I'm saying that Stella is the reasonable suspicion. Yes, Your Honor.
Is Stella the reasonable suspicion, or the fact that the school had learned of a loophole on its prior policy? What gave them the reasonable suspicion to conduct the search in a classroom?
Like I said, because Stella isn't the search, she becomes the reasonable suspicion. Here, Stella, the program implicated with Stella started because there was an increasing drug usage in classrooms, but Stella became the reasonable suspicion. We did not search all of our students. We only searched students that Stella alerted to because she was the reasonable suspicion. Now, I'm not saying that our school does not search students. It does, but we only search students after a reasonable suspicion Stella alerts that she may have detected narcotics on it.
So, Counselor, just to be clear, you're saying that Stella's alert status was the reasonable suspicion and that the teacher's physical search or the administration's physical search of the student was the search?
Yes, Your Honor.
My understanding with the record, respectfully, is we're debating or not the actual sniff was the search.
Mm-hmm.
So we don't get to that level. So would you agree if the nose of the dog touched the student that that would consider a search?
I think if Stella breaches a level of, if she crosses the line and touches a student, then yes, we can argue that that might be a search, but that's not what we're arguing.
So what is that line? So what if it's the nose becomes a quarter of an inch away from the student's groin? Would that be a search?
I think, once again, that is something we'd have to discuss at another level. Like here, Stella isn't necessarily at a quarter, she isn't that close to these individuals, so we can't really determine, we haven't crossed that bridge yet. But right now, our top priority is our students' safety as well.
So my understanding of how smell works is there's matter that's emanated from the thing that you're smelling. So if you're smelling some pasta and spaghetti sauce, it's because some small piece of the matter is actually reacting with your nose, right? So isn't it, if it's close enough for it to be smelt, isn't it, equated to being tactile, might as well be touched? How is it not different?
Well, Your Honor, if my mom is making something in the kitchen and I can smell it from my room, it's close enough to be smelled, but is that also considered a search, Your Honor?
The government isn't at play in your home. So you don't have a reasonable
Yeah.
expectation of privacy away from your mom, unfortunately.
Yes, okay, so what if I'm walking by my neighbor's house and I smell them making dinner and they're making this beautiful pasta dish? That cannot also be considered a search. And also, I'm gonna bring it up in Florida v. Jardins, Your Honor. Give me a second. In Florida v. Jardins, there was a drug detecting dog on this person's property, and they were smelling around, and then in that case, they had determined that that was a search. But instead of that being a search because a dog was there, it was mainly a search because they were going on somebody's property and trespassing upon that person's property. So although the defendant might use that case, there are two different cases. Here there's suspicion of the school violating the person's Fourth Amendment right towards a person, while in that case it was more of the Fourth Amendment right violating towards property, so it's not the same thing.
So if we were to agree with you, how would you define search for us? What would be a search?
I think a search for, in this specific case, I guess, would be just looking through the student's belongings and their specific person, like we did in Ms. Duff's case when we physically patted her down for the narcotics, and we also looked through her property. But Stella smelling the air around her, the orders that we in life just admit on a daily basis is not considered a search, Your Honor.
So for you, the fact that these students you were not touched does not make this a search.
Well, they weren't touched, it wasn't intrusive, it wasn't invasive as well. There are several barriers of privacy that we have respected in this case, where in other cases it may not have been, Your Honor.
And how would that be different from the government using some kind of technology to spy on me in my own home without even touching me? Would that be considered a search?
I think that would be considered a search, Your Honor. But here, we're not necessarily using some technology to spy on them. They're very much aware that this is happening. And like I said, these orders are orders that they choose to admit to the public on a day-to-day basis, Your Honor.
How is there a choice to emit odor, though? Outside of putting on perfume or your choice of cologne, how is there a choice to emit odor?
Well, everyone knows that their body produces smells. If every single person's body producing smells and other people smelling it considered a search, that would be completely unreasonable, Your Honor. So, in Illinois v. Cabalas, 2005, a Supreme Court case was ruled that a use of a drug-sniffing detecting dog during a routine traffic stop does not violate the Fourth Amendment. The court held that a dog sniff is not a search in the Constitutional sense, so it doesn't require additional suspicion, even if the sniff prolongs traffic stop. If this, in the real world, people are going outside and they're just getting stopped by police in the traffic stop, and that's not considered a search, why would we consider it here where students have already a reduced expectation of privacy?
Well, in the traffic stop, it's the dog is being brought there because the officer smells marijuana, correct? So that's one additional step.
Mm-hmm.
This isn't something where they thought Miss Duff, someone smelt Miss Duff and then brought the dog in. So wouldn't that be the difference?
I suppose, but here the school already has reasonable suspicion that children are using drugs in their institution, and Stella is the reasonable suspicion that Ms. Duff might be on drugs, and the search only occurs once the school actually searches the students. So we would like to urge the court to affirm the lower court's decision and state that this is not a search that implicates the Fourth Amendment. Thank you.
Thank you, counsel. You may proceed when ready.
Good evening, and may it please the court. My name is Adelia Mimarova, and I'm here with my co-counsel, Sarah Matsambura, on behalf of the Yarn Hill School District. So the question before this court is whether the program that was implemented violated the Fourth Amendment when a trained narcotics certified dog named Stella briefly sniffed the air around the students in randomly selected classrooms. The Court of Appeals and the District Court both concluded that it did not. The program was non-invasive, it was educational in nature, and it was brief, with students staying seated. Both parents and the students were aware of the process in advance because of the notice that was sent out and because of the assemblies that were hosted, where it was demonstrated how Handler and Stella would proceed. So the Fourth Amendment doesn't forbid all searches in schools. It only forbids those that are unreasonable. And Orion Hill had a responsibility to keep students safe and maintain a drug-free learning environment. This program was not about building criminal cases. It was preventative. It's a school-based safety measure designed to educate students and reduce drug presence and support their well-being.
Doesn't this feel a lot like it's a means for the police to circumvent the Fourth Amendment? In that, I mean, the dog and the handler are members of the police department, and there's a school policy in which any fruits of any search that suggests criminality must be turned over to the sheriff within 24 hours, thereby essentially deputizing the teachers. Why should we not be concerned about that?
Your Honor, we do recognize that the reports were sent to the police, but these reports, they never led to any arrest. There were no investigations done, there were no charges, no student was ever prosecuted. The school simply partnered with professionals to address this ongoing and urgent issue because they themselves do not have the means and expertise to address this issue.
Doesn't that fall onto the special needs doctrine, whether this policy was reasonable in that sense? Because we are now using law enforcement, K-9 unit from law enforcement agency, right? And isn't it true that the special needs doctrine only applies to circumstances where you do not need to use law enforcement officers? When your search is based on reasonable suspicion. Isn't that what that doctrine is all about?
So, Your Honor, the evidence makes it clear that Orion Hill had a real escalating drug issue. It was not a hypothetical concern. It was confirmed by everyone. It was confirmed by the principal, the teachers, and staff. And in response to that, the Board of Education implemented the program to deter students from bringing drugs to school.
But your argument here is that that policy was reasonable, correct?
Yes, because there was an actual issue happening at the school.
Okay, so then it was reasonable because the school district has an interest, a special interest in protecting the safety of the students.
That's right, Your Honor.
And under the special needs doctrine, it's a more relaxed standard, so all you need to show is reasonable suspicion that students' health and safety will be at risk in order for you to conclude that that is a reasonable action by the school district, correct?
Yes.
So how do you explain the fact that in this case, every single student in the classroom is subject to the search? In other words, what is the reasonable suspicion that the school district has to search every single student in the classroom?
So, Your Honor, it was made random because the school's goal was not prosecution. They wanted to avoid biases, they wanted to avoid arbitrary decision making, and every classroom was equally subjected to inspection. So that's why they decided to keep it random. Yes, Your Honor.
What if I question that the school had a legitimate interest in getting to this level of search? And you're saying this rising drug issue, but every school across the country has some level of drugs probably present in the school. And we have a historical record here where there's 1,200 students and there's a few more instances. So less than a percentage point delta from the norm, right? So that is enough to justify this level of escalation?
Your Honor, even one pill could be deadly, and we know that this program was escalating. Students were selling drugs to their classmates. There were baggies found in lockers. So even if it is a small percentage, it is still a real and actual problem that is happening at the school. So, Your Honors, this program was non-contact. It was minimally intrusive, and Orion Hill designed its policy to minimize the intrusion on student privacy. Stella did not touch any of the plaintiffs. She does not aggressively bark, scratch. She does not jump or attack anyone. but her alert is passive in nature. Hilary Duff, Walter Matthews, Jeff Teague, they all acknowledged that they were not particularly afraid of the dog. Again, because of the assemblies that were hosted, and even after the presentation, students could play fetch with Stella to gain further comfort with the dog. So all of our plaintiffs in this case, they were not afraid of the dog. And yes, Your Honor.
What about your colleague's argument related to the intimacy, your privacy interest in the odors emanating from your body? It's not an issue of being afraid of the dog, but whether the dog can smell something that at least your colleagues argue is of such a private nature that dogs should not be sniffing. So how do you explain that? How do you rebut your colleague's argument that this is reasonable because there is no such expectation of privacy in the odors emanating from your body?
Yes, Your Honor. So responding to the petitioner's point regarding the privacy concern, students naturally have a reduced expectation in a school setting. They spend their whole day in close proximity with their peers, with their teachers and staff. In a public school setting, the true solitude does not exist, and students and their parents, they understand that going to a public school comes with a level of oversight. And because of this built-in supervision, whatever privacy they have is already limited and is outweighed by the school's responsibility to maintain safety and a drug-free learning environment. The environment itself makes the intrusion smaller and the justification stronger. Relying on Vernonia v. Earl, students cannot reasonably expect that they are free to bring drugs to school, and drug detection dogs detect and alert to nothing but the scent of illegal drugs. The privacy interests do not exceed...
The interest in the policy, the intention of the policy here is to find people with drugs at the school, correct?
Yes, Your Honor.
Okay, so what's your response to the opposing counsel's argument of the potential for detection of, at home, the parent smokes marijuana, now the jacket smells like marijuana, and the dog alerts. Therefore, we're not finding marijuana, we're finding the remnants of it.
Your Honor, so an alert is not a determination of guilt. No student was punished based on an alert. Stella alerts, and that is simply that this this smell needs further attention. And in Hilary Duff's case, she was not accused, she was not searched. There was further attention brought, and after gaining her parents' consent, only then did the school do a quick pat down. So, yes, we do recognize that students may smell like marijuana or other drugs when they're not using themselves, but that's why there's further attention being brought to these cases.
But wasn't Ms. Duff, by the mere fact of being removed from the classroom in front of her peers, a event that could bring shame and ridicule upon her, and did subject her to physical touch that invaded her person, and was a search that resulted in no finding and no referral for criminal action?
Your Honor, to respond to your first point, we do acknowledge that Hilary Duff was embarrassed, but the constitutional question here is not whether she was embarrassed or not. The constitutional question here is whether it's objectively reasonable under the Fourth Amendment. And to respond to your second point, she was searched, but only after Principal Tompkins called Hilary's father and asked for permission. If the consent wasn't given, the student would not have been searched, which shows that the school operates well within the law. Your Honors, so Stella's accuracy rate is 96-97%.
That would be in a controlled environment, though, counsel, correct? Not in the field?
Yes, Your Honor. It is true that record indicates that Stella's accuracy rate in the field is slightly lower than 96-97%, but that's what certification is for. Certification is designed to demonstrate that a canine is professionally trained, and Stella met that standard because she was trained before being brought to the real world setting. And that is expected. That is what we have the certification for. And this program...
Well, that's not what the certification says, right? The certification says whatever standard we have for drug sniffing dogs, she meets it. Our question about the reasonableness is we look at the technology and We consider whether it's accuracies, we consider whether society's willing to accept it, and we have all these other questions. The fact that she's certified, that isn't the end-all be-all here, is it?
Your Honor, so the Fourth Amendment doesn't require perfection. It requires reasonable reliability, and Stella is reliable. A dog certification establishes sufficient reliability for alerts as recognized in Florida v. Harris. So, a trained and certified canine whose performance is documented and monitored still qualifies as a reasonable safety tool. A trained drug detection dog is like a fire alarm. Like sometimes when it goes off, it may not be a real problem. Like the fire alarm may be triggered by the shower steam or somebody cooking or simply like smoking. But it doesn't mean that it's useless or unnecessary because it isn't perfect. We still have that fire alarm because even one fire. Yes,
What
sir.
if I'm kind of disturbed by the fact that the school went on lockdown procedure during this.
Mhm.
You know, one of the quintessential questions is when dealing with if it was police is, am I free to go? And in this case, the students weren't. So wouldn't that weigh pretty heavily on us, on the fact that not only is this a search, but it's an unreasonable one. It infringes on movement, one of the freedoms most fundamental.
Your Honor, this search was reasonable and there was a lockdown because, again, none of the parents objected. There was communication, there was a notice sent out, it was directly demonstrated how it would work. No parents ever objected, no parents ever expressed their dissatisfaction.
The same question I gave then to your co-counsel. If there was a billboard set up in Tampa, Florida saying, because of our drug issue, we're going to break into every car, or we're going to do drug sniffs around every single car, and if there's detection, we're going to break into the car. Would that be fine if no one complained about it?
No, Your Honor, but if they had an actual issue, then it would be. But our case is different. So, Your Honors, airport and border searches are examples of the same legal principle that we're relying on.
Also, you say it's different, but I want you to elaborate on that. How different it is for the dog sniffing law enforcement activity being held outside on the street versus the policy here being held in a school district. What is the difference between the expectation of privacy individuals have or the liberties outside versus inside a high school?
So,
Please explain in terms of reasonableness. What's the difference?
Your Honor, students were notified of this, and their parents were also notified of this.
Whether or not they are notified, there is also a significant interest in protecting students in the school district. Right?
Yes, Your Honor.
Within the high school. And does that go into analysis of whether this was reasonable or not?
It was reasonable because there was an urgent drug issue at the school that needed to be addressed. So, Your Honors, I would like to move on to my closing statement now. So, the Fourth Amendment asks one question in schools. Were the district's actions reasonable under all the circumstances? And when we look objectively at the full record, not isolated moments and not subjective feelings, but the actual facts of what the district did, the answer is yes. The Yarn Hills School District faced an escalating drug issue among its students, and the district simply chose a method that was effective, measured, and most respectful of students' rights. The canine sniffs were non-contact. They were minimal intrusive. They were passive, and they only lasted seconds. All follow-up actions were handled solely by school officials after getting parental consent. The facts show that a school acted carefully and responsibly, and their goal was student safety. They were not trying to target them. The Supreme Court has consistently upheld limited suspicionless school safety measures. The canine sniff here does not amount to a Fourth Amendment search in the first place. Stella did not physically touch any of the students' bodies or belongings. She only reacted to what was already exposed to the public air. Detecting the presence of a contraband through the airspace is not a search under the Fourth Amendment. Yarn Hill did exactly what the Constitution allows. It adopted a policy that was well structured, that was reasonable to safeguard its students. For these reasons, we respectfully ask the court to affirm District Court's ruling and uphold Yarn Hill's policy as constitutional and necessary safety measure to protect its students. Thank you.
Thank you, counsel. Mr. Cohen, you have 3 minutes on rebuttal.
Thank you very much, Your Honor. I want to touch on a few points that the respondents raised. I think first and most importantly is their argument that the fact that the parents and students did not voice any complaints prior to the district alerting them of this new policy somehow justifies it. I would argue that that's not the case, Your Honor. The fact that there was no objections does not itself imply consent. Would we apply the same logic to, say, a couple that's getting, frisky in bed, and one partner doesn't actively oppose, but they don't want it to continue? Consent is not applied.
When the state get involved in that type of situation.
Right, Your Honor. But my point is, consent is not implied when there's the absence of objection, and that is not the case here. Additionally, they have also leveraged the fact that, this is not deputizing the school's employees because of the fact that none of the evidence turned over to law enforcement has resulted in any arrests. And I would say, just because it hasn't happened yet does not mean we can bank on it for the future. We cannot sit in wishful thinking.
So, counsel, the same question I asked your opposing counsel is the fact that the policy required all students to be, locked down in a classroom, and that every single student was subject to the sniffing of the dog, which, let's assume for the sake of argument now that we agree that that is a search. But why is that search reasonable or unreasonable under the circumstances of this case?
It's a good question, Your Honor. And I would say, as I did in my initial argument, that it is unreasonable because there is no individualized suspicion of any wrongdoing. The school is not acting in a specific group, such as in the case of Roney and Earls, where we have specific sports teams or extracurricular groups that have, a drug problem. There is just the possibility that students might be circumnavigating the original policy, which was,
What makes it different than a magnetometer at the front of the school, which we've considered
metal detector, Your Honor?
Yes, something that's
This
not
is very different from a metal detector in the sense that a false alert with a metal detector is different from a false alert with a drug-sniffing dog. In the case of a metal detector, a false alert could be a number of different issues. Old Joe Schmo that got a false alert, he could have just left his belt on. But in the case of a trained drug-sniffing dog, that is only supposed to alert in the presence or in the traces of narcotics. Anybody who sees that happen would not think, he just left his belt on. No, the dog alerts to drugs. And that is what's going to stick in a student's mind, and it will likely lead to ridicule for students from their peers. Thank you, Your Honor.
Thank you. Your judges will go deliberate for a few minutes, but we'll be back and we'll get everybody out of here. All right. So, first of all, it's not easy to do that, right? And it's especially more difficult with people behind you. You generally don't have to speak in front of a good number of people. So, first of all, let's get a round of applause for both teams. This is something that, it's not easy to do this in real life. It's certainly not easy to do this without any sort of legal background. So it's very funny to watch, and I used to do this with help with a high school. I did it when I was in law school, and I would travel around the country to these competitions. And the one thing I would always be is the more you do it, the better you get. It's mooting it, right? And in order to be able to be a master at this, you have to understand the problem, because you only control what you can control, which may be the first 2 seconds of your argument, or maybe you get a cold bench with a judge who didn't read anything and you've got 15 minutes to just fill. But it's tough. And everyone gets better if you were awful at it the first time, you'll get better incrementally the second time you do it. And if you were great the first time, you'll still get incrementally better. With that said, both teams did a great job, but the Supreme Court is going to reverse, and Jack and Cooper have won this year's Moot Court competition. So, in brief, the reason why it's named, it's called the E.O. Bruce moot court competition here at Hartwick is because of a teacher I actually had in high school who went above and beyond doing stuff that she didn't have to do all the time. She brought kids overseas that in a poor community that otherwise wouldn't. We did JSA. We would go to Boston and do arguments of different sort of things. She had all these opportunities that she wasn't getting paid for on her salary. Now, she died too soon due to a brain aneurysm, but I don't have to do this. This takes a lot of time. All the judges don't have to do this. We have people from across the country judging these rounds, so it's just a big volunteer opportunity, and it's very much in her spirit, which is why it's the namesake. There's also a Best Oralist Award. That is named after Richard Pomp, who is a professor at the University of Connecticut, NYU. He's taught at Harvard. He's a leading expert in state and local tax, federal tax, American Indian tax. He still travels around the country. He's in courts all the time. And he's probably one of the smartest, he wouldn't want me to say maybe, so he's the smartest guy that I know. And with that, it's going to look like he's getting loaded up, but Jack is this year's best one. But before we go, I'm going to pass this along to the other judges if they have any closing comments here.
Well, as I said earlier, you guys should be very proud of yourselves. It is really amazing that you have the opportunity to do something like this. Girls, don't be upset. You did phenomenal. Okay, seriously, you really did. Adilian, I love how you got back at him when he asked you that question about Fourth Amendment, and you got right back at him. And same thing, question that Tom asked you was very good. You're very quick on your feet. And if you watch, which you can, you have an opportunity to watch attorneys argue. If you go to the Third Department website, you can watch them argue. And what you guys see today was no different than what we do, except that we have legal education. We have a ton of cases, under our bag. And you guys just did this in a semester. So this is a couple weeks. So you should be very proud of yourself. You did excellent. You had poise. You understood the facts. You had your legal arguments. You got back and forth with us. If you ever do this again, or anybody in the audience that is intending on doing this again next year, think of this as a conversation too. If you were conversing with us, more so than remembering your notes. I know it's important. You got to remember your notes. You got to remember the cases, the holdings. But it's more of a conversation. You're much more effective if you're looking at us and having a conversation than if you're trying to just spurt out everything that you memorized or want to get out. Sometimes we ask you a question and you were so into what you had written down that you just completely ignored the question. But that happens. It happens to the best of us. But just remember, next year, I'm going to try to make this more conversational. And because you study the case, you know the law, you know the facts, just have a conversation with us as to why we should agree with you. Okay? All right? So congratulations, guys.
Very well done, all four of you. Given where you are, you should stick with this, please. Because I can tell you the legal profession needs good minds and good hearts and people that really want to succeed and improve the law. And so I see that potential in all four of you, and this is a wonderful program that Hartwick has put on, and I hope that you will encourage your peers to do it next year, and come back if you're still here next year to do it again. But all four of you did a wonderful job, and to Carlo's point, it is not just knowing the law and knowing your problem and knowing the facts, but it's flexibility of thought. And so remember that into the future. All right, thank you all for doing this.
I do feel like these guys are my bosses because trying to give me more work. This won't be next year, but we'll see you in 2 years. But but just in closing here, so like anyone who got to do it or maybe felt intimidated about it, like, you know, anyone who did this, like there's a couple things that you're supposed to take out of it. One, you have to read this problem. It's not that crazy, but it's, it's a bit, it's two decisions, and you work on your, ability to take something here and try to understand it. And you have to learn how to read cases, and you have to learn how to distinguish things, an argument. Why this case isn't like this case. That doesn't apply here because of this. This does apply here because of this. They have to think about public policy. And the biggest thing, which is important because it doesn't happen at all colleges, you have to be able to take a position that you might not think is the right position. And I guarantee that, especially the kids that got to argue a number of times, is the one thing that they thought, the problem that they thought was the easiest side, by the end, it's the one that they would rather not have. They preferred the other one because you stress about what's the counter argument to this, what's the counter argument to this. But yeah, everyone is improved throughout it. Certainly the people that you got to see tonight, but even the people that didn't make it, everyone, developed skills during this, and that part's rewarding for the contestants, the judges, anyone that's around. So thank everybody. Have a good night.